Hello, I'm Adam Kielich of the Kielich Law Firm, and today's short video is about the EEOC. The EEOC is the Equal Employment Opportunity Commission. It's a federal agency responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee on the basis of race, color, religion, sex, national origin, age, disability, or genetic information. The EEOC also deals with illegal discrimination against an employee or job applicant because a person complained about discrimination, filed a formal complaint of discrimination, or participated in an investigation or lawsuit of discrimination. Specifically, the EEOC is responsible for enforcement of these laws. Most people are familiar with their job filing lawsuits against employers who have discriminated against employees or applicants. It's also the place where people can file complaints of discrimination, but they do some other work generating regulations and other guidance around the federal laws that they're responsible for enforcing, and some of this guidance plays important roles in employment discrimination litigation. The laws enforced by the EEOC include Title VII of the Civil Rights Act, which deals with discrimination on the basis of race, color, religion, national origin, or sex. It also includes anti-retaliation provisions. As part of Title VII, there's also the Pregnancy Discrimination Act, which makes discrimination on the basis of pregnancy or childbirth or related medical condition an illegal form of discrimination on the basis of sex. The EEOC also enforces the Equal Pay Act, which makes it illegal to pay different wages to men and women when they perform equal work in the same workplace. They also enforce the Age Discrimination in Employment Act, which makes it unlawful to discriminate on the basis of age for employees or applicants over the age of 40. They also enforce Title I of the Americans with Disabilities Act. Title I is the part of the ADA that deals with employment discrimination. The other titles deal with discrimination in other areas of society. They also enforce certain provisions of the Rehabilitation Act of 1973 that deals with disability discrimination in addition to the ADA. They also enforce the Genetic Information Non-Discrimination Act, which is a fairly new law that prohibits employers from discriminating against employees or job applicants on the basis of certain genetic conditions or other genetic information. In addition, as these laws have been amended or added to, such as with the Civil Rights Act of 1991 or the ADA Amendments Act in 2008, they're also responsible for enforcing those provisions as well. As I said, the most common function that people think of with the EEOC is their task in litigating against employers who they allege have discriminated against employees and applicants. This is actually a very small portion of what the EEOC does. Their litigation budget is fairly small, so they really have to pick and choose the kind of cases that they take. Most complaints of discrimination that go to the EEOC are either dismissed or sent back with a finding of discrimination, but for one reason or another, the EEOC has decided that they're not going to file a suit on their own. The vast majority of the work that the EEOC does involves these complaints of discrimination, or what they call a charge of discrimination. A charge of discrimination is a formal document that's filed with the EEOC by what's called a charging party, which would be an employee or a job applicant who alleges that they've suffered some sort of discrimination by their employer or a prospective employer in a job applicant's case. When a charge of discrimination is filed, it's assigned to an investigator with the EEOC who can send requests to the employer for information to conduct the investigation. They'll also work with the employee or applicant to get information from them so they can assess the situation. Once the investigation has been concluded, the file is sent up to one of the EEOC's attorneys who reviews the file, makes a determination if there's more investigation necessary. If there is, it goes back to the investigator for that work. Otherwise, they assess the file, determine whether there has been discrimination under the law, and if there has, what course of action they can or should take. If it's decided that there's no finding of discrimination, they'll send back notice to the charging party of their conclusion. At that point, the charging party has a brief window of time to file suit against the employer and pursue their claim on their own through the courts. Otherwise, if the EEOC decides that there may be discrimination, or there definitely is discrimination, the first step will be to go through sort of a mediation process if the parties will agree to it. Try to get it resolved at an early stage. After that, the charging party can either decide to go through an administrative law process with the EEOC, or they can decide to take their case out to the normal federal courts and file a suit that way and prosecute their claims. In the rare case where the EEOC actually agrees to take on a case, they'll decide how they want to proceed through litigation, and in many cases, the charging party will hire counsel to include other claims outside of these federal laws that go along within the same lawsuit. It should be pointed out that the administrative law process through the EEOC is an exclusive process for federal employees who work for a federal public entity. For private employers, those cases are going to be directed through the normal federal courts, even if there are not additional claims to be added by the charging party to those claims brought under the federal laws that the EEOC enforces. Probably the most important point to know about a charge of discrimination is that it is an absolute requirement before any federal litigation can be filed on the basis of employment discrimination, with the exception of claims under the Equal Pay Act. Anything under Title VII, the ADA, the ADEA, GINA, the Rehabilitation Act, these charges have to be filed with the EEOC, with one exception, before a lawsuit can be filed. And if a party fails to file and follow the process for a charge of discrimination, their lawsuit can be dismissed. And based upon the time requirements for the charges to be filed and for lawsuits to be filed, by the time a case is dismissed, it may end up resulting in that charging party, or who should have been the charging party, not being able to pursue their claim. Now, I said there's one exception to that, and that is that in Texas and a number of other states, we have a state agency that conducts similar business as the EEOC, but for the state laws that are analogous to these federal laws. In Texas, that work is done by the Texas Workforce Commission. They enforce, in addition to their other work, Chapter 21 of the Texas Labor Code, which makes it unlawful to discriminate on the same basis as federal law in almost all cases. Instead of filing a charge with the EEOC, a party can also, instead file a charge with the Texas Workforce Commission's Human Rights Division. They will do the same kind of investigation. They coordinate with the EEOC so that multiple investigations don't have to occur. The Texas Workforce Commission will issue either a right to sue notice with a finding of discrimination or without a finding of discrimination, and let the party take their chance with the court system in filing suit. There are some important differences between whether a charge is filed with the EEOC or the Texas Workforce Commission. These are probably a little too complex for this short of a video. But it's important that this charge is filed with at least one of the agencies before a lawsuit can proceed, with the exception of the Equal Pay Act. In a lawsuit, claims can be brought under both federal and state law, provided that the charge has been filed, as well as related claims that do not directly fall within the federal or state claims. These are rare, but certain types of claims can be brought as well. But without that charge process, the employee or applicant is going to be cut off from a lot of the remedies that they should have. The EEOC, and the Texas Workforce Commission for that matter, generally doesn't like to work with charging parties who have already hired attorneys before the charge is filed. They kind of like to have their own run of the party without an attorney involved, except their own. I disagree. There's a lot of problems involved with how that charge is constructed and drafted when the charging party signs it, that has a later effect on the way that litigation plays out. And since the EEOC is unlikely to litigate any individual charging party's claim, it's vital that that charge of discrimination is accurately and completely filled in with all the information that the party will need to conduct later litigation on their claims. I can understand to an extent that if the EEOC is doing all the legwork in the case, that there would be some displeasure with having another attorney come in and collect a contingency fee off of their work. That I can understand, but given that the EEOC rarely ever takes on cases and file suit on their own, it can leave the charging party sort of stuck in the wind if they don't have an attorney in the beginning. Additionally, the EEOC will not file claims under under state law, so the charging party essentially needs to hire an attorney at some point to additionally bring in those state claims and give themselves a better opportunity to recover for whatever discrimination occurred. So with that in mind, I generally prefer that people come and talk to me or an employment lawyer in their area before any contact is made and a charge is filed with either agency.